All right, looks like we're live. Yep. Hi, everybody. Welcome. Good morning, good afternoon, wherever everybody is based. Welcome to this webinar where we'll be comparing privacy laws today, specifically the EU's GDPR and California's CCPA and CPRA. My name is Yana Gaitangieva, and I'm a lead privacy analyst at OneTrust DataGuidance, where I manage our Americas and Caribbean team. My role focuses on researching global privacy developments and working closely with our network of experts to provide guidance and assist companies with their compliance efforts. I'm really happy to welcome you all today, and I'm very delighted to introduce our two expert speakers today from Neumeyer and Dillian. First joining us is Jeff Dennis, who is a partner and head of privacy and data security at Neumeyer and Dillian. Among many other things, he has an expertise spanning issues from cybersecurity strategy to incident response and complex litigation. He's CIPP US certified through the IAPP and has worked with California business leaders and companies that do business in the state to implement the new regulations and mitigate their impact. So we're very lucky to have him joining us today. We're also joined by Kyle, who is an associate at Neumeyer and Dillian. He has very wide expertise and experience in various matters, which include corporate, real estate, finance, intellectual property, and construction law. Among his various other skills, he regularly supports his firm's research and uses an analytical mindset to problem solve with a focus on alternative dispute resolution processes. So another person we're very lucky to be joining us today. Thank you both and welcome. Before we kick things off, just a note to our listeners, you will have a chance to submit questions to our speakers throughout the webinar. You can do this using the chat box, which appears at the bottom of the control panel, and we'll try to address as many of your questions at the end of the session, time permitting. And one final note, this session will be recorded and available on the OneTrust DataGuidance website. So jumping right in, today Jeff and Kyle will address various things. They'll give us an introduction into the CCPA and CPRA and provide a comparison between the GDPR and the CCPA and CPRA on topics which include the scope and basis for processing, controller and processor obligations, data subjects' rights, and compliance and enforcement. So as this webinar will run for the course of an hour, I'll swiftly hand you over to them to commence the discussion.
Thank you, Anna, and appreciate OneTrust hosting us today. Kyle and I are very excited to be with you this morning for us, or this afternoon, this evening, wherever you may be in this world. But we wanted to, tell you a little bit just from the outset of what this is and what this isn't. Right, today's presentation is going to be, in many ways, a general overview of what's going on in both California and European privacy, and how they are similar and how they are different. We will get into the weeds, so to speak, and a few details on a couple of items, but let's be frank, we could spend 20 to 30 hours dissecting every piece of the GDPR and the CCPA and CPRA to give a complete and thorough rundown of exactly what these privacy regulations do entail. So we have a big job for us. We have limited amount of time. We will try to get to as many questions as we can. Obviously, you do have our contact information, so if there's anything that comes up after the presentation, feel free to email us. We're happy to respond. And again, we're here to help educate and inform. Obviously, it goes without saying, you hear lawyers say this all the time on webinars. These are the opinions of both Kyle and myself. They should not be construed as legal advice. We obviously encourage you to seek counsel who can speak specifically to your particular situation. So now that we have all that kind of out of the way, let's talk about this. And I think we want to start with, where are we with respect to California privacy regulation? And it is an evolving situation. We have the CCPA, which is the California Consumer Privacy Act, and the CPRA, which is the California Privacy Rights Act. The CCPA came online January 1 of 2020, so it's a couple years old. It was the first comprehensive privacy regulatory framework in the United States. However, it fell very short of GDPR in terms of scope and depth. but it was a big change. It was a huge change for companies that do business in California, especially for those who didn't do business in the EU and weren't familiar with the GDPR. There were a whole host of amendments to the CCPA that came out both before and after the act took place. These were promulgated at the time by the California Attorney General's office. And so in the mad rush for companies to try to become CCPA compliant, they were also dealing with the challenges of having these new regulations and amendments pop up while they're in the process. So it was a bit chaotic. I was, looking back at the end of 2019, I laugh at how incredibly busy it was to try to get everybody in line to survive the CCPA. And lo and behold, as soon as the CCPA took effect, the CPRA, the California Privacy Rights Act, was introduced, again by Alistair McTaggart, who was the same individual who started the CCPA. The CPRA was a little bit different in that it actually was a ballot referendum, Proposition 24, in the November 2020 election, which passed by a wide margin, which was expected, and it really strengthens the CCPA. It literally takes the CCPA and builds on it it's the same act. It's a lot of the same language. If you compare the two, you can literally take a red line of the CCPA to get to your CPRA. Again, it strengthens the CCPA, brings it much more in line with the GDPR, although it doesn't quite get to that same level, but we'll talk about that in a moment. So just sort of a high-level general comparison between the GDPR and the CCPA or CPRA. I'm just going to refer to those together as the California privacy laws. It is important to note that the CPRA, I should have mentioned this earlier, doesn't come online until January 1 of 2023. So it is coming. Companies are in full swing in trying to comply with the CPRA before it comes into effect. But I'll refer to both of them as the California privacy laws just for ease of reference, so you don't have to keep hearing me say CCPA and CPRA, although I'll probably do that as well. But the GDPR obviously applies to data controllers and data processors with a presence in the EU, those who either collect and or process personal data of residents of the European Union. The processing is largely based on consent. There is required auditing. These DPIAs, which we'll talk about a little bit more, are required. You have data protection officers for companies that must comply with the GDPR, which is different than what we see under the California laws. And you can see, the list of items here on the slide. I don't want to read them to you, but suffice it to say, the GDPR is incredibly complex, very comprehensive, and really sets forth the fundamental privacy rights for residents of the European Union. The California laws, the CCPA, CPRA, are a little bit different. This, again, applies to companies that do business in California and collect personal information of California residents. You must be a for-profit business to be required to comply with the California privacy laws. And there is a threshold in terms of annual revenue, which we will detail here in a moment, that will force you to be in line with requiring you to comply with the CCPA and the CPRA. Anything that is collected wholly outside of the state of California, processed, utilized outside of the state of California, not subject to the CCPA, CPRA. And you'll note as we go through this that there's a lot of sort of dissimilar jargon, if you will. But the ideas are the same between the GDPR and the California Privacy Acts. There is a lot of overlap in what they are trying to do. They may use a little bit different terminology, different jargon, but you're seeing the same themes that run through both of these privacy acts. One of the things that we're seeing now with the CPRA, which brings it much more in line with the GDPR, is this requirement of auditing. We're seeing privacy assessments, privacy impact assessments now being required under the CPRA for personal information that is collected. One of the differences is that we still don't have a requirement for a DPO, a data protection officer, in California. However, for all intents and purposes, I think we're seeing large companies really turn to dedicated privacy officers to assist them with complying with the California regulations, because they are thick, and they do open the door to a lot of different challenges for companies. Another difference is that the data breach rules and regs that you might see in the GDPR don't exist under the CCPA and CPRA, with one exception when it comes to enforcement penalties. Rather, the United States has made it incredibly challenging to respond to data breaches, given that each of the 50 states has a slightly different version of what is required in case of a data breach in terms of notification, reporting, and the like. So it's very complex, and California is no different. We have a different set of rules than any other state in the union. Other thing that is different and that is developing and becoming actually more similar between the California rules and the GDPR revolves around employees. Under the CCPA, there was a broad employee exemption, meaning employees under the CCPA in California had very, very limited rights. In fact, they had no rights other than the right to be informed of what personal information was being collected from them. They had no right to request deletion, request limit use. They just didn't have any of those rights. The CPRA has actually done away with this exemption. And so employees, much like the GDPR, are now going to have the same rights and abilities as they would under the GDPR. Again, we're expecting that we will see some real, I think, direction from the California Privacy Protection Agency regarding employees and exactly what they can and can't do under the CPRA. But and I should also just step back for a moment and mention that the California Privacy Protection Agency, which I refer to often as the agency, is a new body that was created under the CPRA, which is dedicated solely to protecting California residents' privacy rights. And so this is a massive shift from having the California Attorney General's office responsible for California privacy rights. We now have a standalone agency which is solely dedicated to that. So that's sort of the general comparison. Kyle, I'm going to turn it over to you to talk a little bit more about scope and basis for processing under both of these laws.
Thank you, Jeff, and again, thank you, Ayana, for having us here today. So, going into the scope and basis for processing under the GDPR, the usual process is who, what, and how. As for the who, it is natural living persons in the EU, and the what is applying to specific categories of personal information. There are certain categories like racial and ethnic origin, political opinion, trade union membership, genetic data, and biometric data. Of those, trade union membership and political opinion are actually not categories of personal information under the California regulations, so the CCPA and CPRA. And as to how, or rather, what entities have to abide by the GDPR, it includes government bodies, which is another difference from the CCPA and CCPR. Sorry. And businesses. In addition, when we're talking about how this applies, we're talking to the processing activities of data controllers and data processors. Now, as a small elaboration on what Jeff said earlier, they don't necessarily have to have a presence in the EU. They could be US-based, but so long as they are offering goods or services to individuals in the EU, or they're monitoring behavior of individuals in the EU, like for marketing purposes, for research, that would be something that would be addressed by the GDPR. Furthermore, there are certain exceptions, or rather exclusions under the GDPR. There's personal processing. The GDPR would allow individuals, if they want to process the personal information of individuals on their own for their own purposes, it is okay for them to do that. There's also an exclusion for law enforcement. Obviously, law enforcement needs to be able to process the information of individuals as part of what they do. There is also a slight sort of carve out for journalistic and artistic literary expression, where journalists may not have to necessarily go through all the hoops of the GDPR. However, that is sort of a balancing test, looking at legitimate interests of the individuals and the reporters. And again, the GDPR is more geared towards processing data rather than collection, which is more of the focus under the CCPA and CPRA. Moving on to those, again, the who, what, and how. The who, consumers as any natural person that are California residents. Essentially, if you have a pulse and you live in the state of California, you are protected under the CCPA and CPRA. There are certain exceptions, as Jeff mentioned earlier, currently for employees, but those also extend to business data collection. So, for example, if the representative of one business is talking to another, there are currently exceptions where they don't need to provide notice to each other to jot down, say, phone numbers or of the other or contact information of the other. In addition, the CCPA and CPRA, much like the GDPR, covers various categories of personal information. This extends from names, usernames, and login information to biometric data, including olfactory data. So even the way a person smells is covered under the CCPA as a protected data category. In addition, processing isn't really defined in California's regulations. It's more of a focus on collection, buying, selling, and sharing. On that front, the people who are the entities who are subject to the CCPA and CPRA, generally it's going to be for-profit businesses doing business in California. That last bit is a little bit vague, as doing business in California is actively engaging in any transaction for the purpose of gain or profit, meaning that the state could argue that someone is doing business even if the entity hasn't registered in the state, has no physical locations or employees in the state, and the entity may not consider itself to be doing business in California, but there may be arguments that they are. After that, they need to hit a size threshold, meeting one of three requirements: having $25 million in gross revenue, income of 50% or more of their annual revenue from the sale or sharing of customer information, or as it pertains to the amount of customer information and household information collected, buying, selling, or sharing the information of 50,000 individuals or households. Putting this into perspective, California has a population of around 39 million. So all of that is less than 1% of the state. As of next year, it's getting bumped up to 100,000 individuals or households. So it is going to become a little bit harder to meet that one threshold, but at the same time, it is a fairly low threshold to make. In addition, under the CCPA and CPRA, there's no sort of employee minimum, meaning that it's purely possible for an entity with, say, 5 employees or a very small amount of employees to fall subject to the CCPA and CPRA. This also, like the GDPR, there are some exclusions. Anonymized data, nonprofits, government entities those are going to be outside of the purview of the CCPA and CPRA. In addition, most situations where a federal law already exists, for example, HIPAA, the CCPA and CPRA will not affect that information and how notice and everything needs to go for those kinds of information. There are also exceptions for public or peer-reviewed journals for research. The idea being that the California legislature does not want to impact research due to an individual opting out or asking to have their information deleted under the CCPA or CPRA. There's also certain compliance actions when information is needed to comply with law enforcement actions or litigation, meaning that businesses under the CCPA may not have to apply to comply with consumer requests in the event that litigation pops up and they believe that information may need to be retained. With that, I will shift over to Jeff for the next slide.
Nope, I think you might be on mute.
Thank you. Was coughing in the background, put myself on mute, and here I am. Thanks, Anna. There was a timely question that was asked before I get into the slide about the sunsetting B2B and employee exemptions that are seen in the CCPA. And the question was whether there has been any guidance yet in terms of how those are going to be handled under the CPRA. And the answer is, unfortunately, this time, no. We are expecting that the agency will provide guidance in both of these areas, at least we're hopeful that they do, to make compliance a little less challenging for companies. But that's a great question and something that we expect to see in the future. So shifting back to controller and processor obligations under the GDPR, there are a couple of highlights or issues that you consistently see throughout the GDPR that bear repeating. One is that there must be legal grounds for processing of data. A company can't just take personal data and do whatever they want with it. There must be some sort of legal grounds for doing the processing. There are also some very precise and distinct rules regarding recording of what you're doing, maintaining records of processing activities, so that if there are any questions from local authorities, that they can come in and take a look and get that information. There are DPIA data protection impact assessments required for the processing of personal data. However, the one exception to this, and again, this is different than the CCPA, right? The CCPA and the CPRA talk about requirements in terms of annual revenue for profit. The GDPR looks at it a little differently, and they look at they break it up in terms of size of organization. If you have less than 250 employees, you're not going to have these same data processing requirements, except in a few situations that are listed here. If there is a likely risk to the rights and freedoms of your data subjects, is not occasional. In other words, if you process constantly, you're still going to be subjected to these processing requirements. And if there are special categories of data that are included in what you are processing, you will still have to comply with the processing obligations under the GDPR. It's interesting, these special categories of data that you see on this slide are in some ways akin to what I know Kyle's going to get into here in a moment, but there's a new subcategory of personal information under the California privacy laws known as sensitive personal information. And so you're seeing in both of these laws a real effort to, I think, sort of quantify the importance of specific types of personal data or personal information, those being here as special categories under the California laws as sensitive personal information. Also, as I mentioned earlier, data protection officers, DPOs, have very significant roles to play under the GDPR. They have some very specific rules. I'm not going to read these to you, but at the high level, these DPOs are really responsible to be sort of the gatekeepers, if you will, for organizations who are complying with the GDPR. They need to be the contact person for outside sources or internal questions that might come up. They advise and inform processors and employees of obligations, monitor compliance, and as such, they need to be given some level of independence and resources to their jobs. It's not enough just to identify someone as a DPO and stick them in a locked room and hope for the best. That's not going to cut it when it comes to compliance with DPO requirements under the GDPR. So these data protection officers play a vital role. However, you don't see those data protection officers as being required under the CCPA or CPRA. Again, as Kyle mentioned, the California laws really focus on collection and sharing, in particulars around those areas, where the GDPR is very much concerned with processing, which is again, they're trying to get to the same place. They just are going about it a little bit differently. For obligations under the CCPA and CPRA, again, we still need to have a good record keeping. You also have to be keeping good records of DSAR requests that come in, what you're doing with those, whether you have a dedicated program like a OneTrust that automates that and helps you with it, or if you're doing it on your own. You need to keep these records because if you're ever audited down the line, you want to be able to show that you want to be able to demonstrate that you have been complying with all of the specific rules under the California laws and rules. Audit obligations will come about next year when the CPRA takes place. Notification and transparency is paramount in the CCPA and CPRA. There are these notices at collection, which are required. A very specific notice language must be included in any privacy policy. And it's fairly extensive and specific, which is both helpful and onerous simultaneously as you're attempting to comply with these. As I mentioned, any breach responses are dictated by separate statutes, and again, these differ from state to state, which makes it a whole lot of fun. But Kyle, back to you about talk a little bit more about the individual rights that we've mentioned.
Okay, as for individual rights under the GDPR, this is sort of the base that these data protection laws are sort of built on. The first thing is the right to erasure, otherwise known as the right to be forgotten. It is what it sounds like, a right for a individual to go up to a business and say, please delete all the information you have on me. There's also a right to be informed, essentially a right to know who to contact, why their information is being processed, including the legal basis and legitimate interests, as Jeff mentioned earlier. There's also a right to object, essentially a right to withdraw consent for processing at any time, and a right to access personal data that is being processed. There's also a right to data portability. I don't know if any of you have tried this out before or saw it pop up online. A good way to sort of give an example of this is Facebook. Facebook does allow people to sort of download their profiles. If you sort of poke around in their support section, there is an option to do that. And just a slight difference with the GDPR after is there is no right against discrimination for enforcing rights. And that contrasts with California, and I'm jumping a little out of order here, but there's a right to equal service if they opt out of a data sale. Where this comes into play particularly is with things like rewards programs and loyalty programs, where a business may collect information and use information to try and garner customer loyalty. Where if a customer says, delete all the information you have on me, that may result in a different level of service. There are particular regulations for that we're not going to get into right now. But that's sort of where that right is geared towards. It is saying, okay, you can't provide a different level of service just because someone says that they want to opt out of sale. On that front, the CCPA has a right to know, much like the GDPR. except this right includes notice at the point of collection. For any of you lucky people who are with us in California, you may have seen little signs pop up in storefronts saying, hey, we collect your personal information. And then there's a written link to their privacy policy for more information. That is part of that right. There's also a right to access what information is collected and how it's shared. This is slightly different from just having a privacy policy. If a consumer does make a action on this right, it does need to be particularized to that consumer per the regulations. Again, there's also a right to be a right to delete information. It is what it sounds like. It's a right for consumers to just delete their personal information. There's also a right to opt out of sale of personal information and the right to sue for a data breach as part of an enforcement action. With the CPRA, it slightly alters some of the existing rights. For example, the opt-out right now includes sharing personal information as well. And since the CPRA introduced categories of sensitive personal information, things like social security numbers and other information that is generally protected either for purposes of avoiding identity theft or avoiding substantially embarrassing or harassing an individual. Those categories of personal information, consumers can limit use and disclosure or otherwise restrict that personal information. There's also a right to access information about automated decision-making and a right to opt out of that technology. We're expecting regulations on those further elaborating in July. There are audit obligations, which are not technically an individual right, but Jeff is going to mention those a little later. And there is a right to correction. This is a right for a consumer to sort of knock on the door of a business and say, hey, please fix my name or fix my address. It's something that many of us may have expected would already happen, but now it is a solid right under the CCPA and CPRA. As it pertains to enforcement, CCPA, CPRA, they have statutory damages. It is $7,500 at the high end per violation per person. This is enforced by the California Attorney General or Privacy Protection Agency. Just to give you an idea of what this might look like, you're looking at maybe $750 million on the low end if you qualify because of that size restriction where you collect, buy, sell the data of 100,000 California consumers. That would create a very high a very high damage number. In addition, for data breaches, consumers do have an individual private right of action as well as an enforcement right given to the Attorney General. This is $100 to $750 per incident, and again, this is per person or actual damages. This is unique in California in that in prior data breach litigation, it was very hard to prove exactly what the damages were unless substantial identity theft occurred and they could point to specific damage. Now there's just a statutory number to give potential plaintiffs a solid ground that they can point to saying this is the damage number. GDPR, similar. There is a possibility of monetary penalties to be issued by supervisory authorities, and they do consider multiple factors. They cap out the damages at the higher of 2% of global annual turnover, 10 million euros, or the higher of 4% of annual turnover, or 20 million euros. It depends on the type of violation. To give you all an example, a while back, Facebook was fined under the GDPR, and that ended up being, I think, around 250 euros, which converts to around 255 million. And it converts to 255 million million dollars in US. Apologies, it is still the morning here. It is left to member states to establish their supervisory authorities, and again, under the GDPR, there is a private right of action. What makes this unique compared to California is that private right of action pertains to more general enforcement measures. So giving the example, California entities have at maximum 90 days to respond to consumer requests. If they fail to respond within 90 days, a California consumer cannot go after that company seeking damages under the CCPA and CPRA. Whereas under the GDPR, if a company fails to abide by a provision of the GDPR, that individual can go after that company seeking enforcement. They can also lodge complaints with supervisory authorities who will do so for them. So I'm just going to turn it over to Jeff to finish everything off.
Thank you, Kyle. A couple things to add, and then a couple questions I wanted to briefly respond to that I'm seeing from the audience. One is that one of the I think the fallback positions for companies under the CCPA was that under the CCPA, companies had a 30-day right to cure. If they were given written notice of a privacy violation from a consumer or the California Attorney General's office, a company had a chance to make it right. Unfortunately, that right to cure is gone under the CPRA. So it's imperative that companies get it right the first time when they're dealing with California privacy laws. Another question that was in the chat was whether the CPRA replaces the CCPA on January 1st, 2023. And the answer is yes, but it's not really a replacement because the CPRA is basically, they took the language of the CCPA and augmented it. They modified it. They added quite a bit to it. It's still under the same code sections as the CCPA. There are a few new code sections, but it doesn't replace it per se. It's not an entirely new law. It's basically an augmentation of an existing law, way to think of it. And then last question, and I'm going to get into how this relates to my conversation here in just a moment, but there's a question about, do small companies need data protection officers under the GDPR? And the answer is, it depends. The size of the company is not necessarily the most important factor of the GDPR. It's what you're doing with data. If you are processing very sensitive pieces of personal data, or if you're processing a ton of personal data that may not be so sensitive, you're required to have a DPO regardless of how big or small your company may be. So it's really focused on what you're doing and how you're doing it as opposed to the size of your company. So again, getting back to this slide, the question that I always get is, if we are in compliance with GDPR, do we need to do anything more to be compliant with the California the privacy rules? And my answer always is if you're compliant with the GDPR, you are most of the way there, right? The GDPR, if we're being very frank, is stronger than the CCPA, much stronger than the CCPA, and still stronger in some ways than the CPRA. So if you have a GDPR compliance program in place, you are going to need to tweak some things, but by and large, you're in pretty good shape. Again, recall that the nomenclature that we see in California is different than what we're seeing in Europe, so you may need to change some of your language. The CCPA, CPRA also require these extensive notices of collection, which Kyle mentioned. So if you are collecting information not only via your website or via email or in person, at or before the point of collection, you need to provide these very specific notices which tell the consumer, what it is you're collecting and what you intend to do with it. Obviously, some CCPA consumer requests or CPRA consumer requests will be a little bit different than GDPR. So you need to have internal mechanisms set up to handle those as well. At the end of the day, companies who are multinational or multi-state really have to take a step back, look at their privacy frameworks, look at how their companies are operating, and try to determine whether or not they can utilize what's already in place, tweak it to comply with these other privacy regulations that are coming online. Because remember, California is not the only state that is going to have privacy laws in effect come January 1st of 2023. The states of Colorado and Virginia also have privacy laws that will take effect in less than 12 months. So if your company is doing business there, you need to be familiar with those and make sure that you can tweak whatever you have in place to meet the requirements there. And obviously, multinational companies have to deal with laws for everywhere from the EU to Canada to Japan, China. They are all over the place. Brazil. I mean, many countries now have unique and specialized privacy laws, which makes compliance very, very challenging. And so the last thing that I want to sort of hit on, and we've talked about this a little bit, is that how does the CPRA really change things in California? Is it really that dramatic a shift? And in some ways, the answer is no. It's not a whole new framework, right? The state of California already has a fairly strong privacy rulemaking in the CCPA, but the CPRA does change it and augments it, and quite frankly, brings California more in line with Europe under the GDPR than it was under the CCPA. Consumers, as Kyle mentioned, have these new rights. We've got these new subcategories of sensitive personal information. Recall that under California law, personal information is just such a broad definition. It includes almost anything and everything that could be. Actually, the language is reasonably associated with a California resident. So that is a very vague and wide open categorization of what counts as personal information. Now we have sensitive PI, which is a subcategory of that, which we have to pay attention to. Obviously, privacy policies need to be updated because, again, there's quite a bit of very specific language and new concepts in the CPRA that need to be addressed. One of the things that's not on here that really needs some attention are your third-party contracts. The CCPA, and we didn't really get into this because it gets a little deeper and we don't have time to cover all of this, but the CCPA, as opposed to having data processors, they define third parties that process data on behalf of an organization as service providers. So service providers under the CCPA had very specific contractual language that was required. Under the CPRA, that language has been developed even further and now applies to three separate categories of what I'll call sort of third parties, which is a bad way to put it because one of the categories is third parties. But they talk about vendors, service providers, and third parties. And each of them have their own unique definition and unique requirements, contractual requirements, to handle personal information that they may be processing. So your contracts with vendors also need attention. We also mentioned enforcement. Kyle talked about the enforcement that is under the CCPA, lies with the California Attorney General's office. With the CPRA, that authority still lies in part with the California Attorney General's office, but also lies with the agency. And let's be honest, the California Attorney General's office has a lot to do, a ton to do. This new agency is focused on one thing and one thing only. That is protecting the privacy rights of California residents. So you can bet that we will be seeing many, many more aggressive enforcement actions that are going to come out of the agency as opposed to what we're seeing from the California Attorney General's office under the CCPA. So be ready for that. Those are coming, especially because there's no right to cure period now. So they don't have to give you a chance to fix it. They can just come right after you. And last but certainly not least, the ending of the employee exemption will certainly have an impact on what companies are doing vis-a-vis their employees and their rights regarding their personal information. We very much hope to see very distinct, specific guidance come out from the agency over the summer, specifically related to employees and the B2B businesses. Haven't seen those yet, but we're fully expecting to see those in the near future. And with that, Jan, I'm going to turn it back to you for questions.
Thank you, Jeff and Kyle. Really interesting discussion and looking at the questions that are coming in and some of the ones that you've managed to answer. We covered a few of them, but a few additional ones, a bit of a mixed bag with some recap of content you covered and some new points. So the first question I have is for you, Kyle. What are the main actions that businesses should consider to prepare for the CPRA?
Well, when it comes to the CPRA, the main actions that should be undertaken, updating the privacy policy, taking stock of what's already been done. Obviously, if a company hasn't already made efforts to comply under the CCPA, more work is going to need to be undertaken. But really, for the most part, it's going to be looking through that privacy policy, making sure that they have taken stock of what they're doing already, and moving forward from there, patching up whatever isn't working, making sure that training and everything else that needs to be done under the CCPA is still being done, and just sort of keeping an eye out for the regulations this summer.
Thanks for that, Kyle. And just sticking with you for two additional questions from the audience. So the first one that we have is asking, is the $25 million threshold related to revenue generated in California or the company's gross revenues?
The wonderful thing about this is it is just gross revenues. Even if the amount of business done in California is sort of a pittance, it is that it's just a solid $25 million threshold. It doesn't matter if 99% of that is made outside of the state, so long as they are doing business in the state of California and that threshold is met, CCPA CPRA applies.
Mm-hmm. Nice. And one additional question for you. Question is, could you address what constitutes the selling of information under the CCPA and CPRA?
Sure. This is one of the wonderful things about the definitions in the CCPA and CPRA, meaning that they don't necessarily mean what you think they mean. For example, consumers under the CCPA doesn't necessarily imply that money is changing hands. And unfortunately, the same rule applies to sale. So long as you are giving personal information to someone else for some sort of benefit, whether that is providing a service for free or at a reduced cost, that will still constitute a sale of that personal information. So again, so long as something of value is changing hands, it doesn't matter if it's money, that is a sale of personal information under the CCPA and CPRA.
Mm-hmm. Thanks for answering those, Kyle. So jumping now to you, Jeff, a question, again, with all three laws. So to what degree, I mean, we covered this a little bit, but to what degree are the GDPR and the CCPA and CPRA similar? And is it possible for businesses to consider ensuring compliance with the strictest law as opposed to implementing separate measures for each of them?
Sure, and I think we answer this, at some level. And obviously, the laws are very similar in terms of what they're intending to do, right? They're trying to protect consumers' rights to have some sort of control and knowledge over how their personal data or personal information is being utilized. and give them some control over that ability as to whether or not they want their information to be collected and or processed or shared or sold. And so at their heart, I think the laws are similar in terms of what they're aiming to do. Obviously, they are different in terms of some of the mechanisms that they go through to reach that goal, but they do have similar respects with respect to individual rights, record keeping, the ability for consumers to make requests. There are enforcement mechanisms, right? And they're a little bit different, but they have those similar themes in line. And I mentioned earlier about compliance with multiple privacy rules and regulations. I think the best way to do it is to start with the strictest law and rule and work your way down. And you will definitely need to tweak a few things to reach compliance. But if for instance, if you start with the GDPR and take what you have already in place with the GDPR and modify it slightly to meet the specific language that is spelled out in the CPRA, you're going to make your life a whole lot easier than trying to come up with a different privacy framework for each and every jurisdiction or country or state, for that matter, that you do business in. Because at that point, it becomes overwhelming. I have clients now that are pondering the question of whether they have the same consumer rights given to residents of every state in the United States, because at some point it becomes too onerous to have a different set of rules for every resident of every single different state with a different privacy regulation in the U.S. I think it's in a perfect world, we'd have the federal government in the U.S. come out with some sort of nationwide privacy framework. But given the inability of Washington, D.C. and Congress and the executive branch of getting anything done, I'm not holding my breath on federal privacy regulation taking place anytime soon.
Yeah, we've seen that discussion ongoing for quite some time. So yeah, we'll see how progress is on that front. A couple of questions on data subjects' rights. So jumping back to you, Kyle, what does the GDPR provide with respect to consumer rights that's missing from the CCPA and CPRA?
Really, I'd say a more robust private right of action. The CCPA and CPRA, they do not really allow for consumers to go off on failures to meet any of the requirements under the CCPA or CPRA unless it has to do with the data breach. The example I used earlier, if a business fails to comply with a request in the required amount of time, the consumer doesn't really have any recourse when it comes to getting the company to sort of straighten everything out. All they can really do is make another request and hope it gets fulfilled.
I would only add that hasn't changed individual plaintiffs from trying to enforce these actions. There have been dozens and dozens of individual lawsuits filed in the state of California under CCPA, whereby individuals are simply ignoring what Kyle just said. But again, you've got some very creative attorneys out here, and they're trying their darndest to get these things in front of courts.
Yeah, sticky point. And I guess on that, with sticking with you now, Jeff, what would you say is the most challenging changes for businesses that the CPRA is introducing to improve the CCPA?
I think there are a couple things that are challenging for businesses that are already in compliance with the CCPA and are moving towards CPRA compliance. One are the need for these DPIAs, these privacy impact assessments. Those are new. These audit rights, which are coming down, will also be slightly problematic, I think, for companies. But one of the things that I'm most concerned with has to do with these new augmented transparency rights that consumers have. And I'm talking specifically with companies' obligations now to provide consumers not only with what information is being collected, why, who it's being shared or sold to, what it's being used for, but also how long they're keeping it. It's one thing for a company to know what data it collects and who it shares it with. It's an entirely different beast to understand how long you're keeping personal information. And so one of the things that we're seeing our clients do right now is struggle with this whole concept of very thorough systematic data mapping, to understand exactly where your data is, how it's flowing through your company, where it sits, how long it's there. And it's forcing companies to take a long, hard look at their ability to map their data. And it can be a very, very challenging, time-consuming exercise, particularly if you are a company that has acquired others and you have, dozens of legacy systems out there. I mean, it can be a real beast, and one of the more challenging pieces, I think, of the CPRA for businesses.
Certainly. Okay. One question that I have that we touched a little bit less on, but is equally relevant, is with data transfer. So my question is to you, Kyle. How does the CPRA address the transfer of data across borders, and what are best practices for businesses compliance?
Well, as it pertains to the CPRA, it doesn't. Generally, like Jeff said, it's a good idea to sort of perform data mapping to make sure that you know who has what information and sort of going through your systems. A good way that we've done this is working with outside contractors, but really, so long as you can sort of know what teams have what information, you should be in a good place to, comply quickly if need be.
Thanks for that.
Yeah, and I think the cross-border data transfer is not as significant an issue as it is, with information coming out of the EU, thanks in large part to, Schrems 2 and the invalidation of the Privacy Shield, new standard contractual clauses. I mean, and again, that's another topic that could be, hours and hours in the making, but it's not as significant an issue in the state of California as it is in Europe. I think is the summary that I would throw out there.
Yeah, other bigger things for businesses to be considering now with these ones, I guess. Okay, so another question I have for you, Kyle, and I guess sticking with the topic of best practices, but touching upon what Jeff was saying earlier with impact assessments and DPOs. So the question is that some of the key differences between the GDPR and the CCPA and CPRA are with respect to impact assessments and the appointment of a DPO. So what are the main differences, and are there best practices for companies to consider to comply with both of these laws?
So really, the CCPA and CPRA don't have a data protection impact assessment or a requirement for a data protection officer. The CPRA did introduce a audit right for situations where there would be higher risk for sort of identity theft or higher risk to consumers if that information were to be exposed. But there's nothing really solid in the CCPA and CPRA stating that they need sort of a designated data process DPO. However, to comply with both, start with the GDPR, comply with the GDPR, and that will be the best way to sort of move things forward. In addition, just as a general note, having instant response plans in the event of an actual data breach is going to help you with other compliance issues as well, especially when you're looking at the scattershot way that you would have to respond to a data breach within the U.S.
For sure. So planning, and consider the strictest. Unfortunately, love to ask more questions, but running out of time. So instead, I want to conclude with some final thoughts from you both. It will be interesting to hear your thoughts first, Jeff.
Sure. I think that for me, the main theme is if you aren't in compliance with the California privacy laws or the GDPR and you need to be, start now. I would not wait until November of 2022 to get going, because it's an onerous task, especially with these new data mapping requirements. But remember that these are not impossible tasks. There are good folks out there that can help you get through the process, and lean on the privacy professionals whose job it is to keep current on these laws. Especially if you're in-house counsel, you don't have time to deal with all these things on a daily basis. So lean on your support system to ensure that your company is protected under both of these regulations.
Thanks, Jeff. Any final thoughts from yourself, Kyle?
Planning, and constant vigilance. Just make sure that you map everything out. And again, Jeff said, if you haven't complied with the CCPA already, make those efforts now. You do not want to be in the situation where you are rushing at the very end of the calendar year to put something in compliance when we already have all this time to get it done. That, and keep an eye out for the new regulations coming in. That should be coming around July of this year for the CPRA, and take action quickly.
Yeah, it'll be interesting to see what those look like. Just a couple of months left to go. Perfect. I think that brings us to a close. Thank you both for joining us. Just some additional points for our audience. So in the coming days, we'll be publishing our updated GDPR versus CCPA CPRA benchmark report, which we've worked on with Jeff and Kyle. It's an excellent resource for comparing the two laws, and will be available on the OneTrust DataGuidance platform, which generally offers extensive multi-jurisdictional content in a number of areas. And finally, OneTrust is also having another webinar on the 2nd of February as part of a two-part series on the CCPA and the CPRA. So if you'd like to register for that, you can do so on ot.com and continue the discussion that we've had today. But thank you to our audience, and most importantly, thank you, Jeff and Kyle, for joining us.
Thank you for having us. It was a pleasure.
Thank you.
Bye, everybody.